And welcome to Justice Served TV. Michael Bryant here.
And Linda Kenny Bodden here, and that is my dog Tubi in the background.
Just could not be left out of the mix.
Announcing that we have a very special guest tonight. I actually call him, Captain America lawyer. I have named him, and he has his own little Captain American person. I'm going to change this head one day, and I'm going to put Doug's head on it. So that's coming next, because I just think he is one of the most phenomenal lawyers, and I've watched a lot of lawyers in my career, phenomenal lawyers I have ever seen.
That's all right. I'm not sure I give you permission to tear up my doll, but all right. Maybe for Doug. This is kind of a what TF Doug. What the fun is going on there? Once again, to join us is Doug Weinstein. He is the, of course, attorney for Yak Gotti. I always get his first name wrong. Kendrick is the last name. Diamante? No.
Diamante Kendrick.
Diamante
yes,
Kendrick.
yes. Good to see you guys.
Doug, welcome. Apparently you're on the lam somewhere. You're heading somewhere.
I'm heading to parts unknown.
Okay.
So,
good. I hope the prosecution doesn't come after you.
Yeah, in the witness protection program.
I know, right?
Okay, so let's just jump right into this stuff, because this week, kind of interesting. Most trials, you say, hey, there was a mistrial motion. It would be maybe top line. In this case, it's like, what else is new? But it was something. Give us the groundwork for it. I want to show a clip of what actually happened, but just give us the basics first.
Yeah, a very seasoned law enforcement officer, I guess now retired, Investigator Dennis, was on the stand. And they put up a photograph, which I'm sure you guys have, and they were asking, the prosecutor asked him, I believe, when that was taken. And the investigator, who has testified throughout his career over decades, said, oh, it's when he got out of prison. So, yeah, that's why I moved for a mistrial.
Okay, so there's the picture, and this is your client standing on a nice car.
He's standing on YFN Lucci's car, by the way. That's whose car he's standing on.
And in and of itself, not a big deal.
Yeah, it's cool.
But let me go ahead and play, if I can dig this up here. Let me play what happened. Oh, look at that. That's an interesting maneuver. Let me see if I can bring up that video, and we'll see exactly what you had going on there. This is just a couple of minutes, but it'll give you a sense, I do believe. Hold on, stand by just a moment here. Give us a sense of why you got so upset. Okay, here we go.
Your Honor, this one you cannot fix. This is bad character evidence that came in. The state should have prepared their witness. I move for a mistrial. This absolutely cannot be unheard by the jury. It was heard clear as day in his deep, sonorous voice. They have heard it. They have absorbed it. It cannot be fixed. 404A, Your Honor.
Here, whatever response the state might be able to make on that.
Your Honor, that was not the state's intention.
I'm sure it wasn't.
Your Honor, that response didn't even come across my mind that would even have come out of our witness's mouth, Your Honor. The state's intention was to solely talk about the vehicle that he was standing on and the fact that he was standing on that vehicle. If you can just give us an opportunity just to look at some case law just to see if we can.
Your Honor, I'm sorry. How many times has this man testified in a trial? How long has he been I know he's a retired investigator. How long has he been an investigator? He knows he is not supposed to say that, Your Honor.
I would find it surprising if he isn't aware that that's not supposed to come out. I do not believe that the state intended to elicit that, and I think that you actually yourself acknowledged up here at the bench that you don't believe that was the state's intention.
I do not believe it was their intention.
Nonetheless, it happened. Yeah. I'm going to give y'all about 15 minutes or so to find whatever you might be able to find.
Thank you, Your Honor.
All right.
All right, then. So, it was a heated moment there, and I don't think anybody blames you. Apparently what happened, correct me if I'm wrong, Dennis decided to add that, oh, by the way, that picture was taken right after Mr. Kendrick got out of prison.
Right. He threw that in there. I think people watching on the feed, there was some issue with audio, so they didn't really, or y'all were probably watching as well, didn't know what had actually happened. So yeah, that is what happened. I conceded that I don't believe the state intended to elicit that testimony. Probably shouldn't have done that, but live and learn. But I don't know why he said it. All I can think of, it was kind of a big fu to my client, that he was going to try to say this, see what happened. He knows he's not supposed to say it, and that's kind of one of the reasons I was so upset. But you saw the judge's resolution of this. Of course, I didn't get my mistrial. And really, maybe that's for the best, because I would have only wanted one with prejudice. Having conceded that the state did not intend to do that, it may have been a tough point to argue prejudice. But having not gotten the mistrial, I was pleased with the sanction she laid on the state.
Which was, Doug, what was it? It was related to Dennis never getting back into that courtroom. Tell us what it was.
Yeah. And let's talk about who Investigator Dennis is for a minute. I mean, he was really the central investigator throughout all of the shootings that took place in 2015 that the state alleges were retaliatory shootings after the murder of Donovan Thomas. So he's a central figure from a law enforcement perspective of the state putting on their case. So what happened was the judge said, okay, and by the way, this is like the second or third time he testified in this case. The judge said, that's it. We're done with Dennis. He will not be testifying anymore in this case. And then Brian Steele jumped up and said, well, this was great from Brian. It's a team game here. Brian Steele jumped up and said, well, if he's not going to testify, we're not going to have the opportunity to cross him. Which is, of course, our constitutional right. Judge is like, well, you're right. It's all struck. All his testimony from today is struck. And that was testimony about the alleged back and forth on the shootings. There was a lot of tough testimony that came in from Dennis.
Right. I think, can I just interrupt you? I think someone said that he was the one that was supposed to hold it all together, bring it all together.
He was the one that was supposed to piece everything together. I think Gaither tried to do that a little bit earlier, but it was really Dennis that was supposed to piece it all together. His getting thrown out was a huge win for us. And then the judge also said, look, not only is it thrown out, but you cannot add witnesses to your witness list who aren't already on there to go and testify about the things that Dennis was supposed to testify to. And for example, one of the things Dennis was supposed to testify to are the lyrics in the case. So of course, what she gives with one hand, she takes away from the other. So what happened today is the state put on another, I believe, retired law enforcement officer, Underwood, who was supposed to only be testifying about shell casings matching each other in various crimes that occurred. And instead, she's testifying to a lot of this. So if you were watching this afternoon, you saw just constant objections to cumulative, just all kinds of things. We were at the bench all the time because, again, this wasn't the testimony that was supposed to be elicited from her. So they're getting some of it back in, but I don't think she'll be able to have, and I'm not saying Dennis was credible because I don't think he was, but the same degree, she's not up there speaking in that voice of God that Dennis speaks in. And the other thing was having Dennis reprimanded in front of the jury in this way, I think it undercuts all of his credibility from all of his testimony. So it was a huge, huge victory for us yesterday.
Kudos to you for using the word sonorous. That was very good.
It wasn't the best word
last time I've heard that one. So just to put a bow on this, didn't the state make some sort of motion or ask to have some reconsideration as to any of the exhibits, the things connected to Dennis's testimony brought back to life? What's up with that?
Right.
Yep.
So not only was all his testimony struck, but all the exhibits that were entered under him were removed from evidence. So at 9:00 last night, the state filed a motion to basically have the judge reconsider her decision. And okay, so I have a little different angle on it than Brian Steele does. I think I'm sure we're both. Well, he's certainly right, and I think I'm right. Brian's take on it is that this motion just it's not, the case law doesn't really support what they're trying to get. And it's all about rules of evidence and when the judge can exclude evidence from coming in, and 401, 402, 403, 611, all these issues of how the judge can run the court. I think that misses the point. I think the issue is this isn't about rules of evidence and evidence coming in or being excluded. This is about the court's inherent ability to sanction and control the courtroom under Georgia law. The court has the inherent ability to run their courtroom and put sanctions in place that are appropriate. So there's plenty of case law in Georgia on judges being able to strike testimony, on excluding expert witnesses from cases. And I think the state's motion misses the mark. It misses the point and the basis for the judge's ruling. So hopefully it'll be argued that way. I won't be there on Monday to argue it my way, but maybe some others will. Of course, Brian is going to be filing a response to the motion, and he'll be arguing it his way. Brian is a much more effective advocate than I am, so I'm sure that he will prevail. I don't think the judge is going to change her mind.
Well, I have to tell you that I was watching a little bit this afternoon, and Brian, the judge, I think, asked him how long he was going to take to cross-examine a witness, and
Yeah.
he said 35 minutes, and then there was like a beat up to an hour and a half. And my understanding is that people in the courtroom were saying that the jury did laugh with him, that they, he's entranced them with that, because it was so cute, so funny, and just so well taken as to what's been happening in that courtroom by others. So can I ask you a question about our friend Ashley Merchant this week?
I think she's my friend too, I hope.
I know. I think our friend. I mean, she,
okay,
and of course, love her to death. Think she's another great lawyer. Just happens to be in that courtroom here and there. And it's about the letter she sent to the judge regarding her client, Mr. Arnold, Martinez Arnold, who had taken a plea and has been under subpoena since January 2023 to testify. She doesn't want him to suffer the same kind of sanctions that others have had when, of course, they go outside, the prosecution goes outside the plea agreement and then starts asking questions that would implicate their Fifth Amendment. Now, there's been some discussion about that. I understand by prosecutor, is it Abate?
Adam Abate.
Now, I know that you have put out a TikTok that says you're going to be nice to people. We're not going to attack people. And of course, you can be nice to people, but we can be attack dogs because we like to protect our friends here.
Sure.
And Ashley is one of our friends. I think everything Ashley has said is she well documented in her letter. What has been the scuttlebutt in the courtroom? What's been going on with regard to this?
With regard to that letter?
Yes.
The main thing is that the judge asked the DA, I guess, or the ADA yesterday to respond to that, I believe in writing. I don't recall if she put a firm deadline on that response, but she has asked for a written response. I believe the state's answer was they need to the state may have said that they need to understand her position more. And the reason I say they may have said that is because in response to something from the state, the judge said, well, I think Ashley has laid out her case pretty clearly in this. I think the judge called it an 8-page tome.
Very clear.
I think Ashley's position is crystal clear. And she really, her job is to look out for her client's interest, right?
Right.
And what happened today after the revocation of Mr. Sledge, of course, gives her even more concern.
Tell our viewers what happened, because that to me was terrible.
Yeah, I'm not going to opine on it, but what happened with Mr. Sledge is he got on the stand in our case. Now, he had a plea deal. He has had factual acknowledgments in the plea deal, about a dozen of them, if I recall. And he also was required to get on the stand in our case and testify consistent with those acknowledgments. And he got on the stand and testified truthfully, which was inconsistent with those acknowledgments. So the state filed a motion for revocation. It went before Judge Whitaker this afternoon. He has something like 27 years left on probation, which is just insane. But the judge revoked 5 years of that. So they took him away. He's going to the state pen for 5 years, with the balance of those 27 years being on probation.
And that's what Ashley doesn't want to happen to her client. That something
she does
happens like
not.
that. But how does it happen to him and not little Woody? But I won't let you answer that because I know you can't.
Well, I mean, I don't know what else the state is going to do. I mean, clearly, to me, this was intended to send a message, right?
Right.
Um,
You don't testify our way. This is what happens to you.
yeah.
And he
But
certainly wasn't the only witness to testify contrary to the agreement.
He was not. He was not. Why they picked him to go, I'm not really sure, but that's up to them. I just want folks to understand, and this was made clear if you watched the cross-examination of Sledge on the stand. Understand what he went through, where he's in Rice Street, he's locked up. It's been 7 or 8 months that he's in there. It's a terrible place. It's Christmas time. And it's just, you come in here, you sign this piece of paper, you walk out the door, a relatively free man, you sleep in your own bed tonight, or you can go back to Rice Street. And most people are going to sign that piece of paper, especially because he was under the impression that when it came time to testify at trial, he could clarify things that were in those acknowledgments. Or that's how I believe he testified, and that's how his attorney testified in our trial. So you got to understand where he was coming from when he signed off on that. Yeah. But what I'm happy about is he did testify truthfully in our trial. Right. And I think it is I don't have a strong enough word other than it's a shame he's going to prison for that.
Well, I think our viewers have some words about that. Somebody asked, can he testify on your case in your trial? Can the defense call him?
Sledge?
Again, yeah. Can they call him again?
Sure, we can.
About what happened here? I don't know if he can do it about what happened here.
Oh yeah, I don't know if we can do it about what happened here.
Yeah, I don't know if you can do what happened here.
Yeah, I've got a positive note. The last couple of days, in terms of witnesses and progress, it's not bad. It's a low bar that we're measuring it against, but not bad. What do you think about where we are now and where we're going?
Well, what is different in the courtroom this week from previous weeks? Have y'all noticed?
Is Love not there?
Oh, is that what it is?
I don't know.
Is that what y'all think it is? I'll leave it to your expert opinion on why the atmosphere in the court is different this week, and why things are moving at a relatively swift and diligent pace.
All right.
Well, that's our diligent, thoughtful trial lawyer, defense lawyer opinion, having done this for many years, as you know. I know you can't comment.
I am thrilled that they are moving at a more deliberate pace through their witness list.
Yeah, except when I hear lyrics again. When I hear lyrics again, Doug. Oh.
What's that?
When I hear the word lyrics again, again, I go a little bit nuts, and I'm an expert in lyrics because I listen to rap songs. Well, then I'm an expert in rap lyrics too.
Yeah, there's a Jamaican food place across from the courthouse, and I think because I eat there not infrequently that I'm an expert in Jamaican food. I believe that investigator Dennis testified that he was an expert in rap lyrics because he watched Boys in the Hood. No, seriously.
Somebody had a question. I have a question. By revoking the agreement on Sledge, does that not tell the jury the guys on trial are guilty?
Yeah. Except the jury's not going to know about that.
Yeah.
The jury is not supposed to know about that.
Yeah.
The jury is not supposed to know about. So I pray the jury is doing what they're supposed to be doing and not reading newspapers and not looking at social media. Because
except for yours, I wish that. I hope. I'm going to attach it a little bit. Your TikToks are just fascinating and wonderful and informative. Every morning before you go to court, Doug has a TikTok, and he goes on there for like a 2-minute TikTok, and he says what's happening and all, and what it means, and he explains 404. I guess it was A.
404A.
404A, an evidence rule. I'm not going to explain it. You can go to his TikTok and look at it. But it's about the admission of bad character evidence trying to prove a crime, which is what, in our opinion, the state tried to do. But I know you can't comment on that.
That's good.
Oh, I see a question. Did they take the jury notes?
Yeah,
someone said they took the jurors' notes regarding Dennis.
Those notes pulled them out of their notepads.
Sophie, that's a great question.
Pretty much. And where if there were some of the jurors used both sides of the paper. So they, I guess they Xerox the part that they get to keep. Wow. They have a way to do that. So
that's the best they can do. Let's face it. They're not erasing it from their brains. That's the best they can do.
No, they can't erase it from. They're supposed to, but I don't think they can. So
Yeah.
now they know my client went to prison. I'm really hoping they don't hold that against him.
Right. Well, you know what?
What do you think about
How
the
many people do
judges?
we know? How many people do we know now? Picking juries is a lot different than it was 20 years ago. That have
Sure.
people they know went to prison, the people that have drug problems, people that have been in prison for drug
Yeah.
problems. It's a whole different world out there when you pick a jury, because when you don't think that juror knows, but that jury may have a friend whose daughter or son has gone to prison, and they don't hold it against you.
Hey,
Yeah.
Doug, what do you think about the judge sort of splitting the baby by suggesting that had your client not been convicted, which was known to the jury, then it would be maybe a mistrial?
Well, I think her basis for not doing the mistrial, the only reason I believe she said it's not a mistrial, is because there's a count in there on like convicted felon with a gun. And I really get a sense that she believes that this was error. Judge Glanville refused to bifurcate that count. Even though, well, I guess Max Shart moved for that to be bifurcated. He lost it. I wasn't really as involved in the case back then, so I don't recall what we did, but the judge asked us, wasn't that bifurcated? Why wasn't that bifurcated? So you can kind of tell when she gets her future appellate judge ears on, and it's like, oh, that's a mistake. But again, it's not her mistake, but it's a mistake. So what do I think about it? I think she's I guess she's right. But I also think she's right that should have been bifurcated. Think about it. If it would have been bifurcated like it should have been, this would have been a mistrial.
Doug,
What does bifurcation mean?
Yeah. What does bifurcated mean? Because we talk lawyer talk sometimes.
Yeah. It just means you take a part of the case and split it off, and you try it separately or deal with it separately. And so, for example, I'll give you another example of bifurcation. I don't think it's not good practice to have a witness who is both a fact witness and an expert witness. Excuse me. But the state has quite a few gang experts who are both fact witnesses and expert witnesses. And I tried to bar that. I couldn't get that barred. But I at least requested that their testimony be bifurcated. So it was like, okay, now is the fact witness portion of their testimony. Okay, stop. Now is the expert portion. So in a sense, bifurcate, segregate those portions.
Kind
and
of
Judge
on the
Glanville,
fly.
Judge Glanville agreed to that. I believe we have an order on that. It's not really being followed clearly all the time. We even have a little statement that the judge reads, okay, now the fact witness portion is over. He's going to testify as an expert. I don't think it can really solve the problem, but that's a whole different issue that I don't think is too interesting to any of your viewers.
I do think it keeps some attorneys from slopping over the line, working their way around. And before you know it, this lay witness becomes an expert because of the foundation that's been laid kind of under the radar. So I think to have that little announcement, we're now done with this, we're moving to this, may stop some of that abuse.
Maybe so. Okay, my hard stop is coming up. I'm going to go.
We don't want to keep you off the plane there. Having a great trip, a safe trip, sir.
Thank you.
We will
and
check
all the
with you
questions,
again.
by the way, we have a lot of questions. We're going to parse them out. So next time you're on, maybe we can get them answered.
Perfect.
I see a lot of our viewers have questions.
Yeah.
I see somebody wants to pay, but we're going to answer that question next time.
Okay.
We'll put that in the
we'll
the
put
Doug
that on
bank.
the list.
I'm probably happy to answer most of them.
And if you and he's got a heart out, he has to go. But anything, go watch the clip Doug posted on his Twitter account of him and his client working together. And he points out that his client has been in jail in this case or in this trial longer than most people go to law school.
No.
And it's
he's actually sat in
the
courtroom longer than we sit in class. I calculated it.
What's the Twitter handle?
Twitter handle. I think it's just Doug_Weinstein.
Okay.
That's it.
Yeah,
Doug_Weinstein.
I think that's what it is. Okay.
All right.
Okay.
See you guys later. Take care.
All right.
Oh,
okay.
I
So
just hate talking to him. It just
I love talking to him. I hate the fact that he's in this case so long, but we do have a lot of questions. I don't know if we can answer some of them now going on, because I know a lot of them for Doug has and I see that has defense. For instance, Washington Lewis has defense considered asking for a directed verdict. You can't really ask for that until after the state's case. I think I can answer that question for him.
Procedurally, there's no way to do it.
There's simply no way to do it. But so we're going to take all of your questions on Weinstein and take a look at them and all. But as I'm scrolling through them right now, by the way, Raynette points off topic, pray for Tyrone McAlpin, the deaf man with cerebral palsy beaten by 2 cops in Phoenix over
geez.
Hearsay. There's so many of these cases. It's pretty awful. And I notice I bring that back to Weinstein because Doug asked one of the cops, did you ever knee somebody, not my client, on the back?
He got cut off and spit and spit on him.
Right, and spit on him.
That was kind of shut down.
And it was kind of shut down. But you know what? The state played the game. The jury heard it. I'm sure the jury heard it. Now they believe it.
And the fact is, nobody is going to be shocked at that. Nobody's going to be shocked that happened.
Right.
So.
And also, safe travels to Doug. We should have told him that. Has Fannie Willis
I told him. I covered you.
Has Fannie Willis ever been reported to the bar? I see that question. That's a fascinating question. Do you know that anybody can report somebody to a bar for a bar person if they think that you have committed a violation of your ethics rules?
That's
as it should be. So you don't have to be in the case. You don't have to be a voter of Georgia. You can report anybody. And believe me, I've seen it in a lot of high profile cases. And then the lawyer has to go out and hire bar counsel. Normally they try to do it over defense attorneys. Defense attorneys, oh, look at this defense attorney. But when prosecutors do this constant violations that we're seeing here, that in my opinion we're seeing here.
This is outrageous. I mean, they've
done it so many times. Thank you for bringing us great content. I know you were waiting
here comes drama
for 24 hours for us. I know.
She's like in a dance marathon.
You are great. You're great. You should apply to be on the show, because on Wednesdays in the future we're going to try to have like 1 or 2 of our commenters on our show asking questions to us in our show. So just reach out.
And that's going to start. Fingers crossed. That'll start next Wednesday. When
right.
I will be in Orlando for the Boone case. So maybe we should just segue into the Boone case.
Yeah, how's that? Yeah, you all with us? If we talk about little Sarah Boone today, I just want to tell you to start the case before we talk. And Michael will talk about it. The size of the suitcase was 8 7/8 wide. I won't go into 28 inches by 20 inches, but I'm going to do this for you because you're here watching. I got up today. I asked my husband, would you please do my thing? Look at this. I wouldn't even.
How can I
even fit into the suitcase?
How can I nicely say you will not fit in that suitcase?
I'm not going to fit into the suitcase. Okay. Well, maybe the width, maybe the waistline would. I don't know.
Yeah. I mean, this guy was 5'2", 103 pounds. Okay. Right. But even then, he had to be folded in there like Houdini. It's unbelievable.
Yeah.
So you know what this means.
But wait a second. This is the size. This is the width of the suitcase. It's not a little thing.
Yeah. Well, I mean, we've all crammed as much stuff as we can into a suitcase. It's usually not a human. Okay. So we know what this is. It means we had a lot of evidence opened up today. And, there were 10 witnesses. Take that, YSL. 10 witnesses in barely a full day because they had to start with opening statements. Those were succinct, about 30 minutes each person. And I think laid out the stories that each side wanted to tell. From what I've read online, more people gave the nod to the defense than the prosecution. I think they liked the way Owens was totally off book. He was just kind of telling his story, whereas the DA was a little more, Mr. J was a little more, he'd circle back to the podium. People were freaked out because of the audio. We know from Law and Crime, Court TV, our own experiences, you don't necessarily get the best opportunities to hook the audio up where you want to hook the audio up.
Right.
And if they were told, hey, you can put a mic on the lectern, or is it a lectern or is it a podium?
It's a lectern. A podium is what you stand on, right?
Okay.
A lectern is in front of you. It gets confused all the time, but there's actually a Twitter account. Somebody has, I am a lectern.
I know it's one of your pet peeves. That's why I want to make sure I got that right.
I know.
So they got a mic on there. Well, now the guy's in front of it because he's been in front of the jury where you should be. You're trying to connect with those. It's weird. 6 people in the box and 8 people as alternates. I think that's a little weird. I don't know what the court's anticipating. That's a lot, of alternates for a case that's maybe 2.5, 3 weeks. But that's what they got. The audio, just to give a plug to the station there in Orlando, 35, they basically bumped up the gain. That's a word in the audio biz. They bumped up the gain of the audio when these guys were operating in front of the lectern, and so it was bearable. There were some other outlets that, let's just say, didn't do that, and it was really difficult to hear what was being said. Okay. You
But
want? You have anything?
let's talk about the evidence. The 2 cell phone videos. Investigators got off Sarah. First of all, 9 people were on the stand today. 8
10.
finished.
There were 10.
Was it 10? I'm sorry, 10
10.
people. Let me tell you this. We should have asked Doug if he's jealous of what's happening in this trial, if he even knows. 10 people in one day. I think the CSI is still coming back on Monday.
I'm sure
Okay.
she is. Let me hit
go ahead.
one of the points I think was huge.
Go ahead.
What the hell was the sound that happened at about 11:15 that night? Again, we're going back to February 23rd, 2020. And this event takes place over the night from that Sunday night into the Monday. What was that noise? It was testified to by the people who lived on the adjoining apartment. Theirs is a 1 level, 2 guys living there, a couple students. And then the subject apartment is a 2-story, and there's a stairway.
Put in perspective, because the 2 videos where he was calling her name so that he couldn't breathe were taken according to her phone to testify to at 11:12 p.m. and 11:23 p.m. So you have that sound that's going in between. And by the way, remember, this was just before the whole country shut down for COVID, right? Think about that.
It was right in there, right in the mix.
Right in there, yeah. We shut down around March 15th or so.
That period was when the first announcements were coming out that, hey, there's this weird flu. Anyway, so what's that sound? There's not been any, if we know the story as we think it unfolded. She goes upstairs, takes a shower. At some point in their hide and seek, he gets in the suitcase. She finishes the zipping, and then it's face down. So the zipper and the opening are face down. Okay, and then the video stops, and then about 11 minutes later, there's the second video where it is now face up. And somewhere in this mix, there is this loud thump, loud sound that both neighbors describe as shaking the walls. One of them was even on like a FaceTime with his girlfriend, and he's like, whoa, what is that? And she noticed his reaction to it. We've seen nothing in pretrial information or nothing we've learned in this early phase that tells us what the heck that was. And I'm thinking, she tumbled him down the stairs in the suitcase, or what could have made that sound?
That's what our commenter Dizzy says. That's what the autopsy results kind of indicate, that she may have thrown the suitcase. So that's where the state may be going, that his bruises and maybe his bleeding was from that.
Well, it's convenient that nobody else knows. Nobody else was there. So those, to me, that was a key point in the testimony. Let me see a couple others here. A lot of it was foundational stuff. We're certainly going to see closed circuit TV from Publix, the shopping center, the grocery store,
which is where they showed 2 magnums. That's two bottles of wine empty in the garbage can. Now the magnums have 2 bottles in them, so it's 4 bottles of wine that apparently were consumed by the 2 of them, and apparently Jorge bought them at Publix. So that's the Publix you're talking about.
Yeah, I thought they actually spent a lot more time on the whole wine thing than I would have expected. Yeah, these are 1.5 liter big old jugs. And to break it down, not that I drink a lot of wine, but in my experience, you get 4 basic glasses out of a bottle, which means you're going to get 8 basic glasses out of one of these 1.5s. That's 8 from a bottle that would be full. We know that 1 bottle had already been dipped into to some degree. They finished that one off, got another one. Is there any dispute that they were both pounded, they were both hammered, and that they had an ongoing problem with alcohol? Is that an issue?
No, I don't think so. And what's interesting to me, and I don't know how you all feel about it out there in Sarah Boone space watching this, is that if I were the defense, I know it's bad. They're going with battered spouse syndrome, but to me, this story is one of alcoholism, right? And I think that's maybe they'll bring back the husband to talk about that she clearly was an alcoholic. He clearly was an alcoholic. He was plastered when he apparently got into the suitcase. She was plastered. Does your inner intentions that, for all you've done to me come out when you're out there? But I think this whole case surrounds that if we have family members that we see that they are alcoholics, we need to try to get them help, just as if they were drug addicts. There's no difference, right? No difference here.
Sure, except for whatever reason, obviously for the worse, it's more accepted. It's not as, there's not as much activity, not as much concern. There should be. Okay, so I thought, as I'm watching the different arguments, and opening statements, and I'm watching the testimony, and I'm sitting there as a jury member, I'm thinking this could go either way. Remember, the defense is this self-defense based on spousal abuse, which they hope to get to based on her testimony to come. But we're hearing about this violent past. We're hearing neighbors talk about them shouting at each other. Not that it's one-sided, that it's back and forth, the two of them. We hear about the first date he has with her where she ends up curled up in the fetal position on the back porch after a night of drinking and who knows what else. That's the first date. And then
Yeah,
there
but the
are
problem is
additional
with her.
dates.
Yeah, the problem is with her, and I agree to everything you're saying. If I'm a jury member on the other side, but the problem is with her is that when she calls him to suffocate, and has the baseball bat, maybe breaking his fingers.
That's no doubt.
And she at that point he is of no threat to her. The problem I have with that is I'm not sure that's good enough for spousal abuse, even though it's a terrible situation. I think you have to couple it with the alcoholism, that her brain is fried. And so she can't function with that. And I don't think they're going to do that.
Well, the thing in Florida is they don't have quite as liberal a use of the spousal abuse. They need that overt act. They need something that suggests that a reasonable
And she's
person would feel
unlikable.
well, that's true. Well, we'll see when she gets on the stand. That's going to be critical.
You think she's going to be more? She's going to get a makeover by a Hollywood design consultant.
We don't know. We don't know.
Yeah.
I mean, she is very smug. We know that. She's very smart. She thinks. So that's probably all going to just pour out of her.
This is interesting we're having here because, women are supposedly harder on women on jurors, right? I'm all against domestic violence. Matter of fact, we're putting together this whole panel we talked about, But to me, while this reeks of domestic violence, it also reeks of homicide, like murder in the second degree. And to you think it could go either way. And
well, at this point, I'm looking only at the evidence that's now been presented, and it's all been very matter of fact. Here's some stuff that I think was very interesting from the body cam. We had 2 or 3 witnesses that were really laying the foundation for body cam footage. This was from Deputy John Martinez. He was involved 6 years with the SO there in Orange County. Some of the quotes from that piece of body cam. These are from the defendant. Why is he purple? Okay. I'm really scared here. You guys need to know that. It was totally not intentional. Let's see.
Well, I don't think anyone thinks that this was intentional, that she wanted that.
Let me finish. Let me finish.
Okay, you're a juror. I know
you're
in the jury room.
They're gonna think I killed him. They always thought that. I think this is what she said. I'm the white dragon. I think that's what she said.
What the heck does that mean?
I think it meant she was, in their mind, and by there, I think she means his family. And the very first witness was his brother.
Right.
And he admitted, didn't like her. So maybe that's her, and they're Hispanic or some Latin persuasion. And so maybe in her mind, she was thought of as this evil white woman, white dragon.
Okay.
Or I misheard it. I guess that's possible. If I misheard it, please let me know. I thought it was white dragon.
Yeah.
So, this is going to be a very interesting case, and it's moving along. This judge I like a lot, Judge Kranick. He is. I was talking to a local attorney who said this is his first gig as a criminal court judge. He was just brought on the bench, not first case, but his first term. So relatively new. I think 2019 he came in. It sounded like maybe he picked up somebody else's term, and then he was elected in 2020, stayed there, and is there now. Should be coming up on the end of his term. But he is matter of fact. He's by the book. He asked questions of the jury. He asked, when the jury comes back in from a break, he asked each side, acknowledge that that's our jury. Like somebody's going to pull a switcheroo and put somebody else in the panel. But he gets on the record that each side agrees, yep, judge, that's our group. Interesting. He's really officious that way.
Yeah, I mean, it's just you see from our comments, and we're going to take them all in. Yes, so thank you. You can report. Somebody asks how you report a prosecutor. You can report them to the Bar Association of the state or county. Every state is different, and they'll have an ethics committee. Like in New Jersey, there's an ethics committee for each district that we're in, and that's how complaints get filed. So you can kind of Google it. It'll follow the breadcrumbs on Google. But yes, anyone can report anyone for a violation of ethics.
Thanks.
But make sure you have a real report.
No frivolous
for defamation.
No, never. Even I mean, that's part of doing the right thing.
Privilege, right,
Linda? That's part of doing the right thing.
Yeah. Now speaking about doing the right thing, we have one other thing to talk about.
Okay, hold on. I just want to acknowledge Afton, who said I was right about the white dragon. So
okay.
Hashtag white dragon. Let's see if I've got any other notes before you kick me off this subject and we move along.
No, I'm not going to kick you off.
What do you think about the defense? You always attack the investigation. You always attack the process. and there was an admission by one of the CSI woman, I believe it was. Yeah, Melissa. What a great name, Roughgarden. What a great name that is. Sounds like medieval or something. So she said that they didn't test the blood that was in the suitcase.
I think that's
Now,
perfectly right.
I mean, logic tells you, is the defense trying to suggest somebody else's blood was in the suitcase, or are they just throwing that out there because it's anything we can do to make it look like the investigation was insufficient can't hurt?
Or they're going to say she had and I don't see any evidence if she had any type of wounds on her, that maybe the blood came, that it was prior blood from her. But I mean, this whole idea of testing everything in DNA, when you're an investigator, you have to make a decision about what's important to test, because not every single blood spatter is important, or blood spot is important. He's in the suitcase. He's bleeding from the nose. So therefore, a blood is going to be in the suitcase. He's bleeding from the fingertips. There's 2 spots of blood in the suitcase. Common sense tells you don't need
I'm
to
just
test
throwing it out there.
I'm a juror, and I say I don't care. It wasn't tested. This is not OJ. This is not even my case or Hernando's when they screwed up some of the scenes. In my opinion.
If the glove doesn't
what
fit,
is that? Oh, wait a second. What are you doing?
Fit, you must have quit. So here's what I thought was very interesting about the suitcase. It wasn't even empty. It had a tie in it, had a bunch of papers, and it had a hat. I mean. You're right. It's not small enough already. You've got stuff in there. I thought that was bizarre.
Yeah, and remember, we're going to go back to it. It's the size, the length, the width of this.
Yeah.
He's 100. I think he was 105 pounds and
103
5'2".
pounds.
103 pounds.
And you know what's interesting? She's been incarcerated for 4 years now. If you look at the body cam footage, she was markedly thinner back before she was arrested. And we know a little bit about, their dietary habits. Sounded like it was cigarettes and wine. And so, she was much thinner then. And her attorney said she was about the same weight, but not the same strength at that time. Talking about her attorney.
Wait a second. He was 103 pounds. I'll let this out. I'm 115 pounds, 5'5.5". I've lost like 2 inches because I had hip replacements a few years ago. But so I'm not much different than he is. There's no way I'm fitting in that suitcase.
Next time,
no way.
I'm going to come over in about a week or so, and I'm going to see if I can cram you in that suitcase.
Oh, okay. No, we're going to do this. I know, because he's got to pick up his Captain America doll.
That's right.
I'm putting Doug's head on it.
You're losing custody, trying to rip his head off. Okay, one more thing on this case, and then I'll let you go. The attorneys, from the defense, we all know how that evolved. Mr. Owens is number 9. He basically responded to a flyer, but she has a couple other folks there, and one is the name of Tony Henderson. This guy is a story. I'll just give you a little tidbit. Back in 2013, they tried to disbar him because he allegedly had a relationship with a 14-year-old client that resulted ultimately in a baby they believe is his. So other than that,
wait a second.
Nothing really here.
Do that again.
He was representing a 14-year-old client in some sort of juvenile matter. They got involved. She ultimately got pregnant and had the baby, which is believed to be his. So, and they tried to disbar him, but they did not.
They did not. There was a report to a bar. Excuse me, I dropped my phone. I was so upset about that. Report to a bar association. No one disbarred him.
No, they didn't. They tried to, but it didn't happen.
Maybe I should go practice in Florida.
So he's at it. Well, Florida, I love Florida because they keep us alive, it seems, but they don't exactly have the most stringent bar pass rate. Let's put it that way. All right. I think that their first time rate there is something like 85%. As opposed to California, where I went, it's like 45%.
Yeah, I know when I took the New Jersey bar, I was in the 40s, right? 44, 45%.
So Florida is, if you want to practice law and you're not right, go there.
So I guess you can't report anybody for the Florida bar. Maybe in Georgia, maybe it's different, but
of course
I guess there's no standards in the Florida bar. Okay.
Yeah.
Now we're going to move on to something really important that I want you to all weigh in on with the governor's office, because as you know, there's this case down in Texas, Robert Roberson, right? Well, the big news is that he was 90 minutes away from his execution. Michael was following the countdown to this because Michael had called the governor to make sure that he was pardoned or given clemency or not executed, but apparently the governor didn't listen. So some very good lawyering, and that's why we have Doug Weinstein on, because we like good lawyers. It happened by people also associated with the Innocence Project who represented him. He would be the first guy, by the way, executed for this, in my opinion, bullshit, and I'll say that, bullshit, quote, science called shaken baby syndrome that wasn't started by forensic pathologists. My husband's very big on this. In his book that's behind me, actually, He's got a
He
whole
happens to be
chapter on
Dr.
it.
Michael Bodden. Okay, go ahead.
Okay, on this, and he's been is screaming about this for like 25 years. Started by pediatricians, not by forensic pathologists. Anyhow, so last week the appeals court in another case found that shaken baby syndrome was not a science; that it was just what I'm saying, bullshit. Like my cousin Vinny, not my cousin Vinny, because that's a great movie, but like my cousin Vinny said all that guy said was bullshit.
Mouth. Go ahead.
That's me. Just what can I say? My Catholic school education has gone down. But so what's important is that his
Execution was
stayed, but it's not really a stay like you would see from a governor like we had in the Rodney Reed case, which I had a part in. It's a stay pending his testimony in the legislative body. Because what happened here, the legislative body back in 10 years ago or so passed a law about junk science convicting people. And it's supposed to make sure that people who are convicted of junk science have a way of being found innocent when they go into the courts afterwards. The legislative body said, hey, wait a second, you, the courts, aren't really doing much about this. You're not following the law on this. So we are going to have a hearing, and we actually subpoenaed Robert Roberson to come testify before our legislative committees on Monday. But if you're dead, you can't do that. Okay, this is everybody working. Everyone, it's a little difficult. Everyone working together including a bipartisan panel of like 85 legislatures trying to save him. Yep. So his lawyers said yes, that's right. So they asked for a stay, right, of his execution pending his testimony on Monday.
Yeah,
right.
Interesting. I've never seen a case that is more obviously ripe for the Innocence Project or for community
and
consent.
they've been tweeting about this. They've been
they've got a great campaign. That's how I learned about reach out to the
the and so what happened is then today the intermediate court, the appeals court, who ruled last week that shaken baby syndrome is a junk science, said no, we're going to let him go forward and be executed. So they went to the Texas Supreme Court, who's usually not very friendly about these cases, and said yes, we're going to stay it pending his testimony before the legislative committee. So in the meantime, call the governor if you believe that the innocent people who, by the way, everyone, even the investigators who were on the case said they believe he's innocent of this. Like this young girl had pneumonia, that he should not
keep an eye on that because might still need your help. Call the Texas governor. Keep an eye on it for what happens on Monday.
Right.
It's not going to be instantaneous, whatever the decision is, but it's not the normal 30-day stay.
I've missed you all too, by the way. I've missed you on Law and Crime too, but we're trying to do something a little bit different. We're going to have some streaming.
Yeah, you can't use your potty mouth on that Law and Crime thing. You not allowed.
Well, I would say get him by the sneakers instead of get him by the. Oh, I can't say that. No, that's right. I can't say that. I just went down there. I said it, but I didn't say it so you could hear it.
Okay, so before we go,
what's happening?
Congrats to Sheila, the mug winner. That is off in the post, as they say. So I'm sure we'll see a lovely picture of it in use when she gets that.
But Michael, you are the reason why she won this because you are on the road and you're bringing a suitcase with you. Preferably
I'm definitely gonna have a suitcase.
Preferably not one that you're traveling in. But why? What's happening?
Well, in Orlando, you may have heard the Boone case. Yeah, so I'm going down there next week. Check in with one of her former attorneys. Be interviewing him. Obviously, get a better sense of the lay of the land there. That courtroom not so big. But I've already got my credentials, so hopefully I can shoehorn myself
Justice
in there.
Serve TV credentials.
That's right. So, and then we'll see how it goes. I'm hoping she testifies, middle of the week or so. The way that the prosecution's case is zooming along, that's possible. Because I think the defense case might be as long as the prosecution's case in this situation because of the defense.
Right.
So anyway, it's going to be great. So I hope you guys tune in while we are chatting remotely from
we're going to actually
locations.
Tape an episode on Monday, right? Probably won't be live, but we may change our mind. Then you're going to be down there and stay tuned for what's going to be hits. There could be some teasers, right? And then we'll be live on Wednesday at 1:00, and you're going to be reporting a lot to us.
Special guests on Wednesday as well.
On Wednesday at 1:00, yes. Special guests. You guys have been following us.
That's right. Okay, partner. I guess have a good weekend.
And thank you for all following us, watching. We'll try to get to all of your questions, whether it's the next episode, the episodes. Keep them coming. Even send them to Michael Bryan at his Gmail. My MJ, what is that? What's your Gmail for Justice Served?
MJB at bryantandbaden.com or mjb@justiceservetv.com.
MJB Bryant, that Justice Dizzy, you better put it in the stream because
Yeah.
he doesn't even know his own email for our
I've
show.
got 5 or 6 emails. You know, I'm in the witness protection program.
And
Okay.
what's the motto? What's the motto for them?
Try to do the right thing.
And we are Justice Served. Thank you for joining us.